Welcome back to online classes. Yes, students, I am James here. How are you? Today I am going to discuss with you on Evidence Act. Under section 102. Okay. What is that? 102. 102 explain about on whom burden of proof lies. On whom burden of proof lies. That means the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. I will give you illustration. Here A sues B. Sues means file. A file against B for land for which B is in possession and which as A assets was left to A by the will of C. B's father, if no evidence were given on either side, B would be entitled to retain his possession. Therefore, the burden of proof is on A side. Okay. Another illustration. A file against B for money due on a bond. Okay, bond, agreement bond. The execution of bond is admitted before the court, but B says that it was obtained by fraud, which A denies. Okay, if no evidence were given on either side, both sides there is no evidence, A would succeed. As the bond is not disputed and the fraud is not proved, therefore the burden of proof is on B side. I will give you, based on this illustration and the section 102 of Evidence Act, the main points is the burden of proof lies heavily on the person who makes allegation or seeks to implement his right. Seeks to implement his right. Section 102 prescribes the burden of proof on the plaintiff to prove his case in prima facie. That means the primary evidence. Okay. After the plaintiff, the burden of plaintiff means petitioner. The burden of proof shift on the defendant to prove the facts, whatever he denies. Thus, section 102 is based on the ancient rule that who asserts the affirmative of an issue, he must prove. He must prove it. Okay. It is the duty of the person who asserts an issue. Similarly, duty is cast on the defendant who denies the said issue of affirms a fact in his favor and to prove the proof of on his side. Okay, I will give you shifting nature. What is the possibility of shifting nature, one person to another person? That is proving, okay, before the court. The burden of proof is vital in the judicial proceeding. It becomes a conclusive factor in deciding a case. Now, it has become an elementary and indisputable stage in a judicial proceeding that where, for example, A approaches the court. A is a person, okay? He approaches the court of law alleging that he was cheated by B. A must prove how B cheated him, okay? That if he wants to succeed the proceedings, however, the burden of proof is not an inflexible thing. It is most flexible thing. The law gives similar opportunity to B to prove that B had not cheated A. Indeed, the burden of proof shifts more than once in the course of the proceedings. Now it's clear, students? And another issues, another point, not issues. Difference between the burden of proof and burden of adducing evidence. Burden of proof and burden of adducing evidence. There is a clear difference between the burden of proof on the pleadings. Pleadings means at the time of plaint plus written statement is called pleadings. Okay. Those who are filed before the court as a petitioner and those who are denied the petition from the different side, and the judge will framing the issues. Okay, that is called pleadings. And the burden of adducing evidence The former depends upon the facts asserted or denied and determined by rules of substantive statutory law or by presumption of law or fact. Such a burden never shifts, whereas the burden of adducing evidence is a sequence between the parties and thus it shifts. The burden of establishing a case remains throughout the entire case exactly where the pleadings originally place it. It never shifts, however, the burden of proof in the sense of introducing evidence may shift constantly as evidence is introduced by one side or other, as the one scale or the other preponderates. Okay? In criminal cases, the burden of proof lies upon the prosecution, we already discussed, which must prove all ingredients of alleged offences but not on defense. At the same time, the law gives the accused to prove his innocence. Okay? Because any one of the innocent person not punished by the law. We already discussed the earlier video classes. Okay? I think you know very well. Okay, students. We'll discuss another section. Section 103. What is that? Section 103? Section 103 prescribes burden of proof as to particular fact. Burden of proof as to particular fact. That means the burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence. Okay? Sorry. Unless it is provided by any law that the proof of the fact that shall lie on any particular person. I will give you illustration. One illustration. A prosecutes B for theft. Okay? Here A is a person, prosecutes B is another person for theft, and wishes the court to believe that B admitted the theft to C, because B already admitted to C. Okay, now A must prove the admission. And B wishes the court to believe that at the time in question he was elsewhere. He must prove it. Elsewhere means alibi. Okay, he must prove. What are the main ingredient points in this section? What is the meaning of particular fact? Clearly explain this verse. There is one case or issue between the parties. There is here one case or issue between the parties, and that case, if related to a particular fact, before proving the original issue, the party claiming the particular fact must first prove that particular fact. I will give you example. A sues, sues means files against, okay. A sues B for the recovery of money basing upon a promissory note. I think you know very well promissory note. At the time of receiving money, the both parties agree to signed on document. I agree to pay so and so amount the particular date. Okay, that is called promissory note. So here A sues B for the recovery of money basing upon a promissory note. In this situation, A files a suit after the period of limitation, claiming that B acknowledged the debt during the first 3 years period. Under section 103 of Evidence Act, the acknowledgement of debt by B becomes a particular fact, and it must be proved by A. Okay, and another example, we already discussed with that illustration. The illustration appended section 103 A prosecutes B for theft and pleads that B admitted the theft to C. The admission of theft by B to C is a particular fact and it must be proved by A. Okay. And another point in the same illustration appended to section 103, here B wants to give evidence of his alibi. The alibi is a particular fact and that should be proved by B. Okay. And another point of this related section, it is well settled principle of law that the prosecution can succeed by substantially proving the very case it alleges. It cannot take advantage of the weakness of the defense, nor can the court construct a story different from the one propounded by the prosecution and convict the accused on that basis. Okay. And another point of this same section related, accused person cannot be convicted upon a criminal charge merely on the ground that he does not put forward a defense which is open to him. The prosecution must clearly establish its case irrespective of the defense taken. Okay. Okay students, I will discuss another section, section 104 of Evidence Act. This 104 of Evidence Act explain about burden of proving fact to be proved to make evidence admissible. Burden of proving fact to be proved to make evidence admissible. Okay, what is that? Section 104 explain the burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such evidence. I'll give you illustration based on this section. A wishes to prove a dying declaration by B. Here A must prove B's death. What is the dying declaration? Here B's dying declaration. At the time of dying, any one of the persons saying statement before the doctors. Before the doctors, that dying declaration will be admissible before the court. Okay, valid. Or magistrate. Okay, but in presence of in police is invalid, but if corroborating before the magistrate is okay. And another illustration, A wishes to prove by secondary evidence. What is that secondary evidence? We have primary evidence and secondary evidence we already studied, okay, earlier sections. A wishes to prove by secondary evidence the contents of a lost document, because the primary evidence means the original document. The secondary evidence means the copy of the document or Xerox copy of the document, certified copy of the document. That is secondary sources of evidence as per the Evidence Act. Okay, here A wishes to prove by secondary evidence the contents of lost document. A must prove that document has been lost. Okay, A must prove that document has lost. As per the section, I will give you some related points. The objective of section 104 is that a person on whom the burden of proof lies must, in order to succeed, establish at least a prima facie case. Sorry. He is expected to establish his prima facie and not to take advantage of the weakness, real or apparent, of his opponent's case. For example, if the prosecution wants to prove a dying declaration, it must prove the death of the person. Okay, who was said to have given dying declaration. The purpose is that the law does not recognize the principle of giving the benefit of doubt to a party on whom the burden of proof lies. Okay, and another point of this same section 104 of this section, if anyone wishes to prove the contents of the document by a secondary evidence contending that the original is lost, okay, he must prove first the loss of the document. The reason and logic in the condition laid down in section 104 is that the prosecutor or the plaintiff has to discharge its onus of proving the case against accused or defendant beyond reasonable doubt. And another point of my view, the burden of proving insanity in the first place lies on the person who alleges it. Okay, and another related point of this section, plaint and written statement. I already discussed this, what is the plaint, what is the written statement. Okay, I think this is sort of clearly explained in Civil Procedure Code, Civil CPC. Okay, what is that plaint and written statement? Here it is the duty of the plaintiff to prove and establish the facts mentioned by him in his plaint. Okay, plaints filed by the petitioner. It is the duty of the defendant to prove and establish the facts narrated by him in its written statement. Okay, written statement is, another name is counter. Okay, those who are filed from the defendant side or opposite party. Okay, he must prove his own fact. Okay, okay students, let's see another section. Okay, because this is very interesting topic, this Evidence Act. After Evidence Act section 105 of Evidence Act. What is that? Burden of proving the case of accused within exceptions. Okay, he is having exception. Burden of proving that case of accused within exceptions. This section 105 explain elaborately, when a person is accused of any offense, the burden of proving the existence of circumstance bringing the case within any of the general exceptions in the Indian Penal Code or within any special exceptions or provision contained in any other part of the same code or in any law defining the offence is upon him, and the court shall presume the absence of such circumstance. I will give you example here. A, accused of murder, alleges that by reason of unsoundness of mind, he did not know the nature of the act. What happened here? The burden of proof is on A. Okay, A side only burden of proof. If he is proving, the general exception automatically apply and he is relieved from that particular offense. Okay, from the punishment area. And second illustration, A, accused of murder, alleges that by grave and sudden provocation he was deprived of the power of self-control. What happened here? The burden of proof is on A side only. Okay, he has to prove sudden provocation and receiving from the opposite party. Okay, there is no intention, there is no knowledge about that accusation. Okay, if he is proved, he is relieved from the accusation, he is relieved from the punishment area. Okay, what happened here? This is also exception, general exception of this accused. And the third illustration, section 325 of Indian Penal Code provides that whoever except in the case provided for by section 335. What is that 335? Explain about IPC. Voluntarily causes grievous hurt. Note down, grievous hurt. Okay, yeah, aggravated forms of hurt shall be subject to certain punishment. What happened here? A is charged with voluntarily causing grievous hurt under section 325. Okay, this is punishable offense only. The burden of proving the circumstance bringing the case under section 335 lies on A side. A must prove. If burden of lie, A must prove here. Okay, if he is proving, he is relieved from this particular punishment. And I will give you another point of this section. It is the basic principle of a criminal jurisprudence that an accused is presumed to be innocent. Another principle of a criminal jurisprudence is that the accused should have committed the alleged offense with mens rea. That means guilty of crime. Mens rea means the guilty of crime. There is no mens rea is relieved from particular punishment. Okay. It is also one of the fundamental principle of criminal jurisprudence that the burden of proof lies upon the prosecution to prove the offense of the accused beyond the reasonable doubt. This burden of proof cannot be transferred from the prosecution. Okay. And another example of this, my point, where an accused pleads any general exception under the Indian Penal Code, the burden of proof lies upon such an accused to prove such general exception if available to him. The prosecution is not liable to prove such general exceptions on behalf of the accused. Okay, the above illustration appended to section 105 signify the same only. Okay, the first part of the section 105 imposes the burden of proof upon the accused to prove the general exceptions available to him. The second part of section 105 prescribes the presumption which can be drawn by the court regarding the absence of circumstance. However, such presumption may be rebuttable by the opposite party. The burden of proof and presumption shall be considered together. Okay, and another point of view, the utility of section 105 of Evidence Act is intended in the criminal proceedings only. The burden of proof of the accused may well be compared with the burden of proof of a party in a civil case, and just as in civil proceedings the court trying an issue makes its decisions by adopting the test of probabilities, so must a criminal court hold that plea made by the accused is proved if preponderance of probabilities is established by the evidence led by him. Okay, what is the private person? What is the private defense of this section 105 dealings? Okay, the accused with who pleads self-defense required to prove it beyond reasonable doubt. However, such evidence adduced by accused is enough if such evidence stands the test of preponderance of probabilities, making his defense acceptable. I think now it's clear, this portion. Okay, students. Okay, another point of view, what is how the court can consider how the court can consider this exceptions. Okay, it is well settled that even if an accused does not plead self-defense or any of the general exceptions, it is open to the court to consider such a plea if the same arises from the material on record, the proving of any material evidence. Okay, based on this material evidence, the inherent power of the court pass the order. Okay, and what is the standard of proof as per the Evidence Act? The standard of proof requires to prove the general exception is not that much heavy as the burden of proof lying on the prosecution sides. Okay, a leading case, the Periyasamy and another versus State of Tamil Nadu. What is that case? This case already gave judgment, the High Court level. The aggrieved person to appeal to the appellate court, that is the Supreme Court. Here Supreme Court heard all the material evidence and passed the orders that the legal presumptions created in section 105 with the words, the court shall presume the absence of such circumstance. What is that? The court shall presume the absence of such circumstance is not intended to displace the traditional burden of prosecution. Okay. Okay students, now it's clear. I think section up to from 102 to 105 of Evidence Act. Okay. We'll meet you again next video lessons. Okay. Send me your feedback if any one of the viewers or any students or any lawyers or any judicial aspirants, send me your feedback and pressing the box in subscription. I think it is very free. Okay. Thank you students. Bye. Take care. All the best.